Welcome back to the Law and Crime Network, Keeping the Peace. It's July 16th, 2020. I'm your host, Bob Bianchi. Got a lot on the plate today. Let's start with the transparency issue, the police reform issue with regard to releasing internal affairs records of police officers. Both New York and New Jersey are moving in that direction a little bit in different ways. The police unions both have sued, and the judges have put a temporary hold on those orders to release those records. They want to have a hearing. Let's listen. The judges want to have a hearing to determine whether it's appropriate. Let's listen to Bill de Blasio, the mayor of New York, speaking about this last month.
First, as immediate action, all trial decisions now will be published. This was not allowable under 50A. It now will be. The details of the decisions coming out of each trial will be published. Second, by July, we will publish information on every pending case within the NYPD. Every case where charges have been filed, that is 1,100 cases. Those are the ones in the pipeline now. We will publish the officer's name, charges, the hearing date, and the ultimate resolution when it occurs. Third phase, and this is a longer-term phase, but it will allow us to do something historic to create a comprehensive, publicly available set of disciplinary records. This is historic because it will cover every active member of the police force. All records for every active member available in one place, online, publicly. All past trial decisions will be available, and any other formal actions that came out of those disciplinary proceedings. It'll be online, it will be easy to use and to access. This is the nation's largest city. We have the nation's largest police force. For the nation's largest police force to take these actions sends a message, not only to the people of this city, but to people all over this country, that we can do things very differently. That transparency is not something to fear, but something to embrace, because that's where trust and faith will deepen when people see that all this information is out in the open, just as it would be for any of us as citizens. Every officer will be held accountable. And for so many officers who every single day do the hard work, do the right thing, they will know that the work that they do, the fact that they're out there protecting people, will be honored and respected. And for folks who do the wrong thing, just like the rest of us, they'll know that the consequences will be clear.
Okay, I have with me Lisa Lockwood, a regular here at the Law and Crime Network, a veteran both of the military, of the police, SWAT team, author, legal analyst nationally. She does it all. Lisa, welcome back to the show.
Hi, Bob. Thank you.
All right, Lisa, I've been trying to, having been a civil rights attorney, having been a prosecutor, and now as a defense lawyer, try to balance the interests of what we need to do here, because a one-size-fits-all, I think, can be a little dangerous. As I understand, Mayor de Blasio is indicating that even those complaints that have not been founded or sustained, just mere complaints filed against officers, will be released, whereas New Jersey, from what I understand, is looking at only those things where there's been major discipline, demotion, suspension should be released. Now, I'm going to tell you why, in my mind, this is important. Access to internal affairs records as a civil rights litigator is really important, and it used to be like pulling wisdom teeth to get it, and that makes it very difficult for a civil rights attorney to pursue a case because IA records are key. In a criminal case, defense lawyers would be entitled, in my mind, to some information so long as that record is sealed and a judge indicates when it can and cannot be used potentially to cross-examine a police officer. So it helps both the civil rights attorney and criminal defense attorney to properly assess a case. I get it. But making it available for even those things that are not sustained against police officers, it is argued, would be detrimental to their professional careers and is unfair as a matter of due process, and would actually potentially cause internal affairs not to vigorously pursue because they know that these things are going to be released and could sully an otherwise innocent officer. Thoughts?
With the potential of causing possible more corruption. So if you have records that are released, unsubstantiated claims, which there are many false police reports that are put out there and unsubstantiated. I had one on my record that was in my report as a disciplinary, in my disciplinary file. And it was unsubstantiated and something that I never did. However, it's there to follow me forever. unfortunately. Having a trial and having convictions and having officers lose their job because of crimes that have been gone to trial and found guilty makes perfect sense. But police officers having their names exposed for things that they have done in the past, they have been disciplined for, that are minor infractions, do not make sense at all.
Lisa, I want to interrupt you and bring up two examples that are real life examples. They're not theoretical examples. They're not pocket protector examples. They're not statistics from some college professor. I literally have had body cam video of officers who were accused of doing racist things, and the videos clearly exonerated the officer, two officers in one case. I brought the matter to the Attorney General at the time, and the attorney to bring charges against that individual for filing a false complaint. The Attorney General's position at the time was, no, we don't want to chill people, chilling effect on people filing complaints. So those officers were left naked to that kind of activity. And I know of another very documented and ultimately admitted to attempt to get a very aggressive narcotics officer who was making a lot of arrests off the force by having the public literally file false complaints against him to try to get him off the department, none of which were sustained. Are we talking about stuff like that too?
We are, and that's like I said, that's the scary part with all of this. If something like this goes through, again, you're going to have possibilities of more corruptions of police officers, sergeants protecting their officers and not filing those in there. And we need to have that. We need to have a record of all the complaints that needs to be there. And you need to have internal affairs do the investigation on cases of brutality, sexual harassment, improper stops, lying on the stand. No question about it. These are serious infractions and criminal acts. So yes, the exposure should be there for them when they go to trial. No question about that. I am an advocate. But releasing small and minor infractions and releasing the police officer's name takes away from their privacy and their safety.
I'll play a little devil's advocate with that. It also depends on the culture of the police department and whether they're properly investigating those things. So you could have an officer, I've had one that's had 60 or 80 IA complaints that have never been, was all not sustained. So I get the idea that it's important information, but I would rather the transparency be with the people that can affect the change, the lawyers and civil rights advocates, the prosecutors and the defense lawyers with a protective order, and a judge ultimately making a decision as to what can and cannot be released. I think that would be a fair balance. Let's listen to the police union head in New York, Patrick Lynch, as he discusses this issue.
Well, this administration decided that's not good. They demonize police officers. They've changed the rules where it's impossible to do our job, and the criminals take advantage of that. When a criminal hears from City Hall, there's going to be a soft touch on crime. They know exactly what that means. It means there's a smorgasbord on the street, and we're going to take advantage of it. And they have. Where we have children being shot on the streets, how terrible can that be? Well, it's not just one thing, but saying we're going to take $1 billion from your budget because there was a slogan on a sign at a march, and then the mayor says, we're going to do that.
Defund the police.
Defund the police. Now, I love it. As a person that have protested in my life, the protests for fairness for police officers, and I've even marched. I like it because you say defund the police, the definition can mean something to you and something different to me, so they start yelling it. Then you have the cowardice of our city council and the mayor's office trying to figure out what the protesters want. They're not going to stop at $1 billion. They don't want police officers on our streets. They don't want us taking the guns out of perps' belts. They don't want us keeping our children safe in school. Well, what's next? What's the next slogan we're going to chase?
You know, Lisa, look, again, this is about balance. And I wish in everything that we've done here in these special mini-series, which I think is so important and powerful that the Law&Crime Network put together, is that it's not just one end or the other end. If they came together with reasonable responses, and I can again tell you from my extensive experience as the head prosecutor that we have this seesaw effect where there's condemnation of the police for doing police work, and sometimes it's legitimate and sometimes it's not. And so the police then back off or do what it is that the community asks it to do. Violence goes up, and then you get a call back as to why it is that you're not patrolling and properly enforcing laws in those communities, because those citizens, especially in minority communities or lower socioeconomic status places, have an increase in violent crime. It's not a one way or the other way. It's honest people getting together to the table to try to make reforms that strike that balance. What do you think?
Yeah, watching the pendulum swing over the years, far, far left, far, far right, in the direction of protecting the community, hands off, soft touch approach, then to let's have super aggressive community policing in these communities, then it's too much police. How do we make a balance to make everybody happy? It's the hardest thing, and I do agree. How do we get at the table and come to a place where we can decide what's going to be best for the community and to get crime back down again?
And you know what I've noticed at that point, too, and I've been involved in so many of these things, including an overall revamp of internal affairs, not only in my county, but was then asked because of that by the Attorney General to participate statewide when I was county prosecutor, because I had defense, criminal law experience, prosecutorial experience, civil rights experience against police brutality. I think a big problem, I'm going to say this over and over again, it is the #1 issue in my mind as to why we can't get to the proper balanced reform, is that when you get to the table of the people they bring there, they all have political agendas and they're politicking, and they're not really the people with necessarily the most experience that can put the policies together. Has that been your experience?
That could very much, I think you have your hand on the pulse of that. The people that are there at the table making those decisions are tied into their jurisdictions, their mayors, their what they want on the political side versus what the public needs, as far as stopping crime, preventing crime, keeping people safe. That is the job of law enforcement. Their job is to serve. They want to protect. That is their job. But then when it comes down from a higher power that we're going to go ahead and start changing and implementing new programs, again, now we're on the soft touch. And how does that look? 161% crime has gone up in New York City because of let's pull back. Criminals know that. They know that. That's a free license for them to go out there and wreak havoc.
Yeah, definitely. Let's go to one other clip that we have of New York Police Department officers that were injured during a protest on the Brooklyn Bridge.
The bus. It looks like it.
I mean, 3 officers sustained serious injury there. We're seeing an escalation. I've been talking to some of my police friends who are telling me that in an area where there's never been a problem, they're literally being given the finger and screamed at and yelled at. And here's exactly what I want to talk to you about, Lisa. When I was instituting those reforms, messaging is important. Messaging is important. And instead of making it like I believe the mayor is doing, that the police are the bad people and we have to reform them because they're horrible people, what I try to do is to say to the police, we need these reforms so that you're always a witness in the grand jury and not a defendant in the grand jury. And that these reforms are actually going to make you better officers, more balanced officers, and are going to protect your career so you can do your 25 and you can get out with your pension without a problem. When they knew that it wasn't that I was trying to hit them over the head with a hammer, but trying to help them, and by the same time institute reforms that were surprising to them, they bought into that. It was the messaging, Lisa.
It is. And coming from, I'm a Chicago veteran native, and coming from seeing the crime that was happening in the city and also the turnover of the mayors and how it was implemented, the relationship they had with the police superintendent and the firing of different superintendents and all the political ramifications of that. They want a superintendent that's going to go out there and do the job and clean up the streets. But then it becomes a little bit too aggressive. It goes to the other side, and then there's a stop and there's a new sheriff that's put in town, so to speak. So because of the political, as you had mentioned before, the political ramifications of somebody who wants to be reelected and what they're going to do is extremely unfortunate.
Lisa, I think you just hit another thing, a nail on the head, too, with regard to prosecutors. I am so against these elected officials interfering with police operations or prosecutorial operations or even the election of district attorneys and judges. Just my point of view. I know it's controversial because they tend to want to respond to the voters and the constituents, and that does not necessarily bring about reform and good policy. It brings about politics. We got to take a quick break here on Keeping the Peace. We'll be right back. We've been covering this really important subject about the release of the moratorium on federal executions. So we've had a number of people that have been on death row. The law for federal prosecutions and executions is on the books, but for 17 years, it has not been imposed. In a flurry of legal activity that has occurred, the Attorney General last year had lifted that moratorium. We know when we talked here on the Law&Crime Network about Daniel Lee, who was executed after a Supreme Court decision came out at like 2 o'clock in the morning. Hours later was executed, and the family in the Lee case did not want him executed. Talk a little bit more about that. But the other case that we covered for you yesterday was Wesley Purkey. He was convicted in the 1998 kidnapping murder of a 16-year-old girl who was actually raped, stabbed, and dismembered and thrown into a septic tank. It was a terrible case, but the death penalty is the ultimate penalty. We want to make sure we do it right and according to the law, whether you agree with the death penalty or not. And there is a 1986 decision from the Supreme Court of the United States, which should be precedent, that says you cannot execute a person who, quote, lacks reasonable understanding of why he's being executed. The lawyers for Purkey indicated that he has significant Alzheimer's, significant mental health disorders, delusional, schizophrenia, things of that nature. He did not understand the proceedings against him. A district court stopped the execution until they could have a hearing to see whether there was merit to those claims, arguing, the judge, that it would be irreparable harm, that's a term used in the law, to execute a person before they gave them the hearing, because obviously the hearing would make no sense because the person would have been executed. That went to the Supreme Court, and at about a 2 o'clock a.m. ruling, which is so unusual, the Supreme Court said, nope, we reversed all of those appeals and the execution go forward. And now the number 2 person today, Mr. Purkey, has been executed. Another person scheduled for execution on Friday. So the Lee case, the surviving member of the family did not want Mr. Lee executed. She felt he was unfairly treated at trial because the co-defendant who did far worse got a life sentence. But there was a little bit of a different twist in the Purkey case. Let's listen to the mother of the stepmother of the victim.
He didn't want to go back into the state prison. He wanted to go into the federal prison because it's a little more cush for him. So he admitted to killing Jennifer and taking her across state lines. It's so perfect for the crime that he committed. Good riddance. He took such a piece of all of us, and I don't think we'll ever get over it.
Marilyn says she prayed all during his trial.
Lord, if he came to you and professed his sins, you would forgive him. I can't forgive him, so you forgive him for me.
Okay, so Lisa, what are your thoughts about how quickly this is all moving? And I know some could say quickly. What are you talking about? This was 1996, and it's taken all this time. Are we moving too fast? The Lee case is one kind of case, but this case, the lawyers are making a credible argument based upon a United States Supreme Court decision, yet weren't even given an opportunity to develop a record so that a judge could rule on it below. What are your thoughts?
I was a little bit confused on that particular instance because I thought the person had to have mental competence at the time that they were convicted and given the sentence of the death penalty, and they knew that that was going to happen. Not up until all the years that had passed later, the person developed a mental incapacity and dementia and Alzheimer's and schizophrenia. Because if that was the case initially and they were tried, they would have been determined mentally incompetent for trial and then put into a mental institution. So that's where it's a little bit hazy for me as far as that ruling.
Yeah, I would imagine, and I haven't read the ruling, but I would imagine there's a twofold process. But one of them being that he can no longer assist his attorneys in making the last minute arguments with regard to staying his execution. He can no longer be a participant, among other things. Nevertheless, that was the ruling. And I will say, and I think it's only fair to note on the record, from the readings of the articles that I read, it indicated that he actually made a statement where he apologized to the family, said he was extremely sorry for what he had done to the young woman, and said, I don't see what basically, and I'm paraphrasing, executing me does anything to change any of that, which would sound kind of competent in my mind that he knew what was going on.
It does.
If true.
And with dementia and with all of those mental disabilities, it comes and goes, and people can be lucid for certain periods of time. So with that admission and with that apology, it does seem that in that moment he was lucid.
Yeah, well, let's go real quick. You know what? We talk a lot about police reform and stuff like that, but let's not lose sight of the fact we need reform. I've advocated it for an entire career. But let's also remember what police officers do day in and day out, a majority of them, to make a difference in the lives of people.
Before they're approaching me in the driveway. Hey, what's going on with the baby? Okay, let me see. Okay, calm down. Let me see the baby. Hold on, let me see. Okay, hold on. Let me see the baby.
Please.
Hold on.
Oh, please. Where's the emergency?
Hold on. Let me see the baby. He's still blinking. He's blinking. Okay, hold on. Yes, there you go. Okay. He's crying. Okay. He's crying. Hey, it's okay. He's crying. He's crying. He's okay. He's crying. David 10. Baby's crying.
Go, Shona.
Okay? Okay. Yep.
Lisa, I got 30 seconds, but you know what? I say we need reform, absolutely. But let's not throw the baby, no pun intended, out with the bathwater. So talk to me about the heroism of cops, real close, real tight, please.
250 interactions with the public police have every single year, and you better believe life support is one of them. Doing CPR is a regular occurrence for police officers out on the street.
All right. I got to end it there because I got to tell you what, this is the last episode of in the series of Keeping the Peace. But for you true crime aficionados, the greatest headlines of true crime and the content of the biggest things that are going on in the nation legally, with our new segment that will start Monday, Law&Crime Report, every Monday through Friday, 12 to 1. Yours true personally will be on Mondays and Thursdays. Thank you for watching this segment. Stay with us here at the Law&Crime Network.